Welcome, everybody. We're live tonight on Facebook, the Art of Advocacy show. And tonight we're going to be talking about some breaking news that happened yesterday. The Supreme Court heard a very important special education case. So that's what we're going to be using as our focus topic for tonight. So thanks for joining me. I know we all have busy lives. If you or a friend weren't able to catch this live, we always have a replay up on Facebook. So make sure that you share this with other people because, as Pete Wright said, and we probably all know Pete Wright as being a famous special education attorney for parents and students. Pete said yesterday on Facebook that the case that went before the Supreme Court yesterday is a significant case that will have long-lasting impact on our children with disabilities. So I hope that you can, like I said, share this with others. If you're on with us live tonight, feel free to type in comments or questions in the box below. I'm really hoping that this is interactive and it's not just me talking at you, but that we can have some good conversation back and forth with each other. So if you don't know me, I'm Charmaine Tanner. I'm a parent and advocate. I am a retired teacher and author of a #1 best-selling book, The Art of Advocacy, A Parent's Guide to a Collaborative IEP Process. And if you do know me, you know that sometimes I guess I have that name of being called a special ed nerd, and that court cases, regulations, statutes, all those kinds of things are very interesting for me to read. But I need to tell you my disclaimer, I'm not an attorney, so I never can give legal advice. And if you're listening to my interpretation of what happened yesterday at the Supreme Court, please understand that it's not a legal interpretation, but as an advocate, this is a summary that I'm going to be sharing with you. So to give you a little bit of background information first, the Supreme Court case that was heard yesterday comes out of Douglas County in Colorado. And when I lived in Colorado, I actually worked with several families in Douglas County schools, not the family that this case is about. But I did work with other families. One family had a son in a charter school and was trying to get the charter school to make sure that they provided the appropriate program and services for their son. And I worked with some other families there trying to get that appropriate IEP in place and implemented. So Douglas County is right just southern part or just south of Denver. So for you trying to place that geographically, it's a pretty large town and up and coming, a lot of people that live there commute to Denver or to Colorado Springs. But it's also been a district that's had a lot of controversy. I think it was like 2011, the district passed a voucher program that was going to be able to be used by 500 different families in the district. And if they had more people apply, they were going to do a lottery. The problem with the voucher system that they proposed and that they were starting to implement was that some parents were going to opt into schools that were religious-based schools. So there was court hearings and different decisions came down from the court. They were appealed. They finally went to the Colorado Supreme Court, and the Supreme Court in Colorado said, no, you can't have this voucher program. You can't use public money to spend at religious or schools based that were religious schools. So Douglas County isn't new to being in the court cases and in the courtroom. As a matter of fact, that case of the voucher program is still being litigated, and I think the district would like to see it go to the Supreme Court. So that'll be interesting if that happens. But tonight we're going to talk about a different case. So before we go any further, Can you give me a thumbs up or I got you in the comments so I can make sure that everybody is hearing and seeing me okay? Um, let's see if I can make it over here to my Facebook page. Let's see if we've got any questions or comments. Like I said, give me a thumbs up. If you can hear me okay, if you see our camera. So Sherry's on here and Yael's on here. Hi, ladies. Sherry is from Canada. So Sherry, you might have some interesting perspectives of what we're talking about here in the United States. And if you've got some comments, please put those in the comment box. But let's look a little bit about the background of this certain case. Now, this was a student who went to Douglas County schools from preschool through fourth grade. He's a student with autism known as Drew. And as he got a little bit older in elementary school, he started having more behavior challenges, and the teachers were pulling him out of the classroom a lot. And the parents were really frustrated because he wasn't making much progress at school. And then kind of the straw that broke the camel's back was when he was going to be going into fifth grade and the parents got the proposed IEP, and it pretty much looked like previous IEPs. They didn't see any progress being made. So as parents, they decided to place Drew in a private school, one that specialized in helping educate students with autism. And then after he was there, the parents asked the school district for a reimbursement of the costs. And the district denied that, saying that they had offered Drew an appropriate public education in Douglas County schools. The parents had opted out of that. Therefore, the district didn't feel like it was obligated to pay for the private education of that student. Now, my guess is many of us as parents have kind of wrestled with that idea of, well, what's appropriate for my student? And what a lot of school districts will use as the basis of their definition of what's a free, appropriate public education is a Supreme Court case from 1982. And this was with Amy Rowley, and she lived in New York. She was a young student. She had and used hearing aids, but the parents had requested a sign language interpreter for her at school so she could even excel, at a greater rate and make more progress. Well, the justices on the Supreme Court at that time, and remember, this is 1982, ruled that the special education law, the IDEA, all that they required was meaningful access to public education. And the justices at that time felt like the districts didn't have to maximize the potential of students with disabilities. So the Rowley case has been really important. That's been kind of that basic floor of opportunity. And unfortunately, as parents and advocates, we see that as a pretty low bar, and it doesn't really afford our kids the type of education that they really deserve. So let's look at what was the question that they heard yesterday before the United States Supreme Court. So the key question that the attorneys were asking the court is, what is the level of educational benefit that school districts must confer on children with disabilities in order to provide them with a free, appropriate public education guaranteed by that federal law, Individuals with Disabilities Education Act. So this was the crux, and this is something we hear almost daily at IEP meetings that's being debated as far as what's appropriate special education. So I see we have a couple more people that joined us. So hey, Janet and Natalie. And Janet is actually a parent that lives in Douglas County. So I'm hoping that I I gave her a link if she wants to try and use that and see if she can come on, and then she could speak live with us too. So Janet, if you want to try and use that link that I emailed you and see if you can come on live with us. So we talked about the Rowley case. We talked about the question before the Supreme Court. The problem that many school districts, or I guess it's probably more parents and advocates see with the Rowley case, is that it's been interpreted so many different ways depending on where you live in the country. So we have 11 different circuit courts in our country. Well, 2 of those circuit courts use the definition of meaningful educational benefit, and that's how they define appropriate education. But then you have 5 circuit courts, and all they use is this just above trivial standard. So, I mean, that's even like lower than meaningful. And then there's 3 circuit courts that pretty much side with that lower standard, that trivial standard. There's 1 circuit court in the East that is split. Some of the districts and some of the lower courts in that circuit court say it should be meaningful education. Other courts in that circuit say, no, it just has to be above that trivial standard. And then we have the District of Columbia, and that hasn't considered this issue yet, which I find pretty interesting because the District of Columbia is probably the place that we get most of our due process hearings in the country. So I find it pretty interesting that they haven't ever had a case where it's gone up to their circuit court about the meaning of the word appropriate. So we have this student from Douglas County, like I said, he wasn't making progress. His parents put him in the private school. So let's look at what the parents' position was. What they argued and what their attorney argued for them was that Rowley really didn't take into account all the changes in the special ed law, IDEA, when it was reauthorized in 1997 and when it was reauthorized in 2004. And the parents' position was those changes were also reflected in federal education policy. So they said students need more than just access to public education, but they really need to make progress. So it's kind of, sad state of affairs if you think of parents need to go all the way to the Supreme Court to say that their child deserves more than just access to education, but there should be an expectation and an obligation on the district's part to provide an education that's going to help them actually make progress in that general ed curriculum. So I see Natalie's trying to get on. Keeps saying something's wrong. Okay, Natalie, I hope you can hear us and can get back with us. So that was the parents' position. Let's look at what the school district was saying. The school district said, well, that question about what is actually, a benefit and what's appropriate for education, that question was already settled in Rowley. And in that court case, when it went before the Supreme Court in 1982, it said that a child's individualized educational program, or IEP, should be reasonably calculated to enable the child to receive educational benefit. So the parents were saying, yeah, we had this case, Rowley, in 1982, but we also had reauthorizations that changed that. The school district was saying, no, Rowley was a case before the Supreme Court, and we should keep that standard that they used in that case. Well, as I just said a couple minutes ago, you can see that all the different circuit courts in our country, there's been so many different decisions, which really isn't fair for families because it depends on what state, what circuit court area you live in as to what kind of education your child may receive. So, indeed, as Pete Wright said yesterday, this case is very, very critical. The standard that the Supreme Court will rule on and set is going to have such long lasting impact on our students. So, it's critical that we try to, move forward and try to get the education that kids really deserve in our country. So that was the district's position. Now, yesterday they went before the Supreme Court, and the Supreme Court heard their oral arguments. First up was the attorney that was representing the parents. Jack Robinson is actually the Colorado attorney that helped the parents all through that process. And Jack was at the Supreme Court yesterday as counsel. But the attorney that did the the oral arguments for the family was Jeffrey Fisher. And his point was the federal law, IDEA, requires a program that's reasonably calculated to provide him or her educational opportunities that are substantially equal to those offered other students. So here the attorney is saying we need stronger language. We need to be able to define what that word appropriate means and how much benefit students with disabilities are entitled to in our public schools. And he said it's not only something that's reasonably calculated to give them benefit, but it also has to be substantially equal to that of education that's offered to other students. So that was his argument. And then it was interesting when I read the transcript for it. And speaking of transcript, I do have the transcript. It's like a mere 77 pages or something, but I do have the link for the court oral argument transcripts, which is, for me, a special ed nerd, is interesting to read. So if you would love to have some light nighttime reading that might for sure make you fall asleep, write in the comments, yes, give me the transcripts, and I'll send you that link for it. So as I was reading the transcripts, it was interesting because they had like I said, the parents' attorney spoke first, and he, even after, only after he had given a few sentences of his argument, right away some of the justices started asking him questions, which I thought was interesting. I wasn't sure if he would just have, a full time to do his oral argument and then questions. So I wanted to show you some of the reactions that the justices had to the parents' attorney argument. So first, Justice Kennedy spoke, and he talked about the concerns of cost. And he said, if you look at Amy Rowley and the parents were asking for a sign language interpreter, that would have some amount of cost. If you look at Drew's case coming from Douglas County in Colorado, his parents were saying that he needed a private school education, which would cost a lot more. So Justice Kennedy brought up the concerns of cost. And of course, we know as parents and advocates, our students' education is not supposed to be based on, what's the cheapest way for districts to do things. But another Justice Breyer spoke up, and he said that he was worried about creating a new standard that could be interpreted differently. He said, we are justices on the Supreme Court, but we're not experts in education or special education. And he felt uncomfortable trying to create a new standard, a new definition that would probably go back to school districts and parents and still have that problem of how you interpret it. While some other justices weighed in, and the Chief Justice Roberts and Justice Kagan said, well, what about students who, because of their disabilities, might not be able to follow the general education curriculum? So I was a little disappointed when I heard this because to me, we always have expectations that our students with disabilities are competent and that we can have those high expectations for them, and that they will usually achieve with what we expect from them. So his Justice Roberts' kind of first remarks were talking about kids with more significant needs. How could we expect them to be able to make progress in the general ed curriculum? But the attorney for the parents replied, there's in the law, in IDEA, it talks about students who, have challenges making progress with the general ed curriculum as it's written. You can have alternative benchmarks, but you still have that expectation that the kids are going to be, the students will be learning at a high level. So he tried to answer their concerns in that way. Well, then it's interesting because the next attorney that spoke was from the United States government. I mean, you think about, wow, there's an attorney that actually represents the United States government. And he was testifying in making oral arguments in support of the parents and Drew, the student. So that encouraged me because it's like, yeah, we have an attorney for the parents and the student, but now we have an attorney from the United States government. And he also is supporting the request and the arguments that the parents and their attorney made. And he said, well, the federal law, IDEA, requires a program that's aimed at significant educational progress in light of the child's circumstances. So that was his kind of new language that he was proposing. Well, I don't know. The thing that I worry about is we've been fighting for years about what that definition of appropriate is. And is it meaningful? Is it some benefit? Is it significant benefit? And then I think, if we come up with a new standard, is it just going to be new adjectives that we still have to go back to and, fight and battle through the courts on what that new standard means? So that's kind of my only caution, is if we're really going to be able to create something that is clear for everyone to understand. And after the attorney for the United States spoke, one of the justices made that same point that I was talking about, was that IDEA, she thinks, sets a clear standard for what's a benefit for and what would be an appropriate education. And she said the problem is coming up with the right words that will be less confusing. And so if we know about lawyers and, legalese, it's like this is going to be a task for the Supreme Court to come up with some kind of clear wording that's not going to be confusing, that would be understood, and would have a universal definition. Now that, I don't know. I think that might be kind of very optimistic, right? Well, after she had spoke, then the attorney for the school district had his time to make his oral arguments. And he talked about, and he equated the term some benefit and said that that was more than merely de minimis standard. So that's the new buzzword now, de minimis. And he was trying to say that when a school district provides some educational benefit to students with disabilities, that some benefit is actually higher than this low de minimis standard. So that was his argument. Well, then the justices had some comments and some questions for him. And the first one that spoke was Chief Justice Roberts. And he said, when you use that phrase, some benefit, it's problematic because of all the court cases in the past that say it really needs to be enough benefit to keep track with grade progress. And that would have to be more than just the de minimis. So you can see already we have attorneys and Supreme Court justices using different adjectives, using different phrases, and it's trying to see, which one would give the student more benefit, what would be the word that we could use. So it will be interesting to see how this all plays out, right? So I'm going to check if you guys have comments or questions. Elle said yes. She agreed that the Justice Sotomayor was saying, what she was saying was absolutely right. That the trick is going to be picking those words that are going to be less confusing. So we also had some more reactions during the time that the attorney for the school district was speaking. And Justice Byers said, well, IEPs need to allow children to make progress in general education. And that was something that the federal law said when IDEA has been reauthorized. And he went on to say that a combination of some benefit and make progress are more stringent than what the district was arguing for. So from this short statement, I got my hopes up and it was like, well, Justice Byers seems to understand it. And I must say, I was impressed. I think the justices asked good questions and there was a good conversation about things. And I was kind of surprised how much background information they had about the federal law, IDEA, about the IEP process. You could tell that they had done their homework and that they were prepared for hearing the oral arguments. But anyway, so here we have a justice saying, if the law says we have to have some benefit, but we also have to make sure kids are making progress in the general ed curriculum, that's going to be at a higher standard than what Douglas County was saying that they were obligated to do. So let's look here. The attorney for the district tried to come back to answer the justice's response and their questions of him. And the attorney for the district said, well, more than the minimus standard has been in place for a long time across the country, and it really hasn't been a low standard. So he was trying to still argue that something a little bit more than trivial as far as a benefit for education was a standard that a lot of school systems and courts used across the country. And there hadn't, I guess, in his opinion, been that much of a problem. He didn't feel like it was that low of a standard. I guess as a parent, not that I guess, I know, as a parent and as an advocate, I would say that in a lot of places, the level of, standard and the level of expectations that districts have for students and the kinds of supports and services that they provide for them are often really minimal. And unfortunately, that bar has been set so low that kids can have poorly written IEPs, and the districts will come back and say, well, we gave them some benefit. They made some progress. Therefore, this was an appropriate education. So, Yael, who's an advocate in Colorado, said that it's a joke that it hasn't been a low standard. That's all we deal with as advocates. And I would certainly agree. I mean, one of my goals is to work myself out of a job and not have a need for special education advocates, but I don't think that's going to happen probably in my lifetime. That's the biggest reason why parents call us as advocates, is because they feel like their child's program isn't appropriate. It doesn't provide the supports and services that their kids really need. So let's go back here. That was what the attorney said. And then I also thought it was interesting. I saw a list of different organizations that are supporting the parents' position. This was really interesting. More than 100 current and former Democrat members of Congress think that the district's low standard is contrary to our federal law, IDEA. So more than 100 current and former Democratic members of Congress. So these were members of Congress that helped write the federal law IDEA, that were involved in, reauthorizing it and changing and improving the language both in 1997 and 2004. And they were saying, we agree with the parents. The district's standard for meaningful education was too low for Drew, and it's too low for other students. The other groups that have been supporting the parents, like I said, it's the United States government. So that's a nice organization to have on your side. And what it was is the Solicitor General's office is the one that submitted a brief in support of the parents, and the U.S. on behalf of the United States government, they said that the district's position does not embrace high expectations, but instead is just that de minimis, that low standard. And then, of course, you might guess, a lot of disability advocacy groups issued briefs in support of the parents' position. And also, I was happy to see that the National Education Association, which represents teachers and a lot of paraeducators, they also are in support of the parents' position. Then you might guess who the supporters for the districts were, for the district. There's this Council of Great City Schools, and it's actually the country's 70 largest urban school districts. And they have an organization called the Great City Schools, or the Council for Great City Schools, and they submitted a brief in support of the school district's position. And then you also have a coalition of school administrative groups, and they supported the school district. So Yael said, I thought that the Supreme Court requested the Solicitor General's office to comment before they agreed to take the case. And yes, you are right, Yael. They did. They wanted to get feedback from the Solicitor General and getting some response also and some input from the Department of Education as far as, if this would be a good case to go forward. The other thing that I thought was interesting, because I wondered with, there's a vacancy on the Supreme Court. So then I thought, oh gosh, is this going to be one of those decisions that comes down 4-4, because we only have 8 justices now. But in one of the articles that I read, they said that it was actually a good sign that the justices decided to hear this case. And in this reporter's mind, it showed that the justices thought this won't be a time when we have a split decision. They felt like the justices, would have at least, a 5-3 decision come out. They said there's more controversial issues before the court, and the justices have delayed hearing those until they get that 9th person. So, to me, I took this as another good sign. Hopefully, the 5-3 comes out in favor of the parents and the students. But so that'll be something that we'll, just have to keep watching. So let's see. Before I talk to you about what happened at the end of the day, besides the link that I have for the transcripts from yesterday's hearing at the Supreme Court, I also have quite a few links from other organizations that have weighed in, or people like Pete Wright that were actually in Washington, D.C. Yesterday to be there hearing in the audience. Pete wasn't an attorney representing the family or anything, but there were a lot of attorneys that represent families and students that were in the courtroom yesterday. So if you're interested in getting some of those links, type in, yes, give me the links in the comments and I can send those to you. So we have another person on with us, and Charlene said, wow. So yeah, there's a lot happening. And like I said, this is going to be one of those cases that's going to have an impact for a long time. So we're crossing our fingers and being hopeful, right? So at the end of the day, yesterday, actually it was end of the morning, some of the attorneys that were there in the audience, their conclusion was that they felt like the justices seemed unhappy with the more than merely de minimis standard. And there was also some consensus among the attorneys in the audience that this ruling may come out as early as the spring of this year. There's a deadline that the Supreme Court would have to rule on it by the middle of June, but we might hear as soon as springtime. So I'm cautiously optimistic that we're going to have a Supreme Court decision that will have a positive impact on all our students. The part of me that is still concerned about the language is, will we just change the wording, change the adjectives, but still have it to be, open-ended and still not exactly be able to have a way to measure a standard that all students, all 6 million children with disabilities across our country, what is going to be the standard that can apply to each and every one of them for what will be that free, appropriate public education. So, well, it's a matter of time, right? We'll have to wait and see. But I think there'll be a lot more discussion going on. So make sure that you like my Facebook page, visionsandvoicestogether.com. That's the page that you're on right now watching the live show. And after you like it, then you'll get notification when I'm going live. Basically, if you can just write on your calendars, every Thursday evening at 7 o'clock Mountain Time, we'll be live with an Art of Advocacy show. A couple times a month, I'll have guests on. And then a couple times a month, like this evening, I'll just be kind of talking about one of those hot topics in special education. I wanted to tell you about next week's guest. I'm excited about her coming. She is the president of the Northwest Down Syndrome Association out of Portland, Oregon. Angela Jarvis Holland is coming. She also is the coordinator of a wonderful inclusive conference called All Born In. And so I've invited Angela to be our guest next Thursday night at 7, and she's going to be sharing a little bit about her journey as a parent and also giving some tips to follow up on what we talked about last week with Molly Mahoney when we talked about how parents can recognize the wonderful gifts that they have and how you can use some simple strategies to be more confident when you go into IEP meetings. So until next week, have a wonderful week. Keep your ear to the ground. This will be an important case we keep hearing more about. And I wish you the best of luck as we continue on this journey of advocating for our children. We got to keep on keeping on, right? So take care, and I'll see you next Thursday.